looking for another delegate who's supposed to join me at the podium, Mr. Jitanji. Okay, if anyone wants to speak on behalf of China, please come and join us. Today's topic is basically some issues in patent prosecution and a comparative study in various jurisdictions. We'll deviate from the standard format and treat this like a question-answer session. So I have prepared a set of questions which are and then I will ask the delegates from various countries to give answers based on their jurisdiction. So we have a couple of people from the US, but one of them will focus on the chemical side and the other one from the software side. Somebody from Japan and then South Africa. We had someone from China. So anyway, I will first introduce the speakers and then I'll get on to the questions. So at the end of each question, I can throw the discussion open to you if anyone has questions on that topic. So we can make it genuinely an interactive session. Okay. First of all, we have Robert Stoll. He is a partner with the law firm of Brinker, Brittle and Reed. And more importantly, before that, he was the commissioner of the US Patent Office. In that capacity, he was instrumental in passing, in getting the new AIA, American Inventors Act, formulated and passed. He had a very important role in that. He's also a part of the CAFC Advisory Council. In 2012, he received a Lifetime Achievement Award from Managing Intellectual Property magazine. So we have Robert Stoll. Then we have Mr. Hironobu Hattori, a partner with the law firm of Nakamura and Partners. He's qualified as a Japanese patent attorney. He has been practicing prosecution and litigation in chemical and medical fields for almost 15 years. He received a Master of Law degree from University of Washington in Seattle. He also has a Bachelor of Science and Master of Science degree from Sophia University in Japan. He also studied medical and biotech-related IP issues in Tokyo Medical and Dental University. Hattori. Then we have Mr. Rowan Joseph. He's a partner with the South African firm of Bond Sales. He's a patent attorney. His expertise includes prosecution of local and foreign patents and registered design. He is an experienced litigator specializing in chemical and generic pharmaceutical matters. His expertise includes preparation and filing of South African and foreign patent applications, intellectual property licensing, and copyright matters. And finally, we have Soumya Panda. He's an associate with Rothwell Fig law firm in Washington, D.C. He concentrates his practice on patent matters in the electrical engineering field, including preparation of and prosecution of patent applications. He has extensive experience in patent matters involving technologies such as wireless communication, satellite networks, digital signal and image processing, etc. So further ado, I'll get on to the questions and then let each speaker answer on behalf of the administration.
for that question. I believe that we're going to see, as I said this morning, the pendulum start to swing back. I think that these decisions, and as far as they relate to pharma issues, I would say that's Prometheus and Myriad. Alice basically was a software-related type of decision from the Supreme Court. I believe that what we've seen is the high watermark for what I call the preemption argument, and because in fact patents do preempt. But what they're looking at now is the preempting the basic research tools, which is to quote some of the cases. I think you've got two cases coming up, probably to the Supreme Court, as I mentioned earlier today. One dealing with a revolutionary method that reduces pain and stress and possibility of injury, which is the fetal testing method, which analyzes the blood of the mother, and they've surprisingly found that there's enough fetal blood there to determine whether or not there are abnormalities in the fetus. Because that is naturally occurring, the courts until this point have said that is something that's not patentable subject matter. Now, if you read the decisions from the Court of Appeals from the Federal Circuit very closely, there are several judges there that say, we don't like this outcome, that we feel compelled to do it based upon the fact of the way the Supreme Court has made earlier decisions. But there's some concurrences there that specifically say they don't like it. I think that kind of thing, it's not going to get expanded to that. I think the Supreme Court will retrench its positions with respect to patent subject matter area and allow an invention like the one done by Sequenom. I likewise think in the software area the same thing will start to happen. And I can tell you for a fact that the intellectual property owners, the American Intellectual Property Law Association, and the ABA, the American Bar Association, IP section, have all got on hand drafted legislation to reverse this if, in fact, the Supreme Court does not make a decision that narrows the application of naturally occurring methods. Remember, these are judicially created exceptions in the first place. There's no basis in statute specifically for it, and it doesn't say anything about it in the Constitution. We had what was occurring for 30 years, a very liberal application, particularly in the biotech and pharmaceutical method, and I'm talking specifically about diagnostic methods in personalized medicine, which would be eviscerated if these decisions continue. There was established precedence in the Patent and Trademark Office for 30 years of granting these patents. So it is an activist court that is making a decision that says they're no longer patentable subject matter. And I think that the patent bar and the scientific community now agree that this will have a chilling effect on job creation, research, and economic growth, and I think that they will reverse it.
As I see it, in the next 100 years, regardless of the field of technology, even if it is chemical or automobile or something, innovation is coming primarily from the information sciences aspect. Its control, its algorithm. To that extent, patent will be of algorithm-related subject matter is quite important. Unfortunately, as Saul alluded to, that's being eviscerated. So, I'd like someone to comment on the same topic from the software standpoint.
So, what really comment on here is that what we've been seeing is that there are ways to work. There are many ways to overcome this issue. And a bit of a background, it's the history of jurisprudence and eligible subject matter. This is a long, convoluted history. And it used to be, when you get statutes 35 U.C. 101, which covers eligible subject matter. And it used to be when you get a 101 rejection, you talk to the examiner and you say, okay, your it's too broad for a purely software implementation. Add a computer and or so you add a processor, you can overcome the one-on-one rejection. 5 years later, your case comes down, and you talk to the examiner, and you tell the examiner, okay, what if I had a computer? And the examiner said, well, that's not enough. All you're doing is calculation. You need to show. Not only do you need to show that you're tied to a machine, you need to show that you have a tangible result. You're making transformation. And so now, 5 years later, now we have the Alice decision. So now it's it's a two-part test. It's you first, are you directed to an apps? You have a one-on-one rejection. You have to tell the examiner, at first we're not directed to an abstract idea. 100% of the time the examiner say yes, you are directed to an abstract idea. So then the real meat of the test is now, are you adding significantly more to the abstract idea? And what this means is that can you show the examiner that you have a technological solution to a technological problem? You're making an improvement to a technical field. So in this history, what we can see is that the bar has been raised. And so maybe 5 years from now, who knows what the Supreme Court will say. Maybe you have to show your invention came as a prohibition from God. I don't know. But at least from the prosecution standpoint, it's not necessarily a lost cause. There is actually a sense of optimism now with software inventions, particularly at least getting applications prosecuted through the USPTO. The USPTO themselves have now come down with some guidelines, with some working examples showing this is, if you have a computer implemented invention, this is what's considered patent eligible subject matter, this is what's not considered to be patent eligible subject matter. So with these guidelines, it provided at least a template or a framework that we can work with, that we can advise clients on, where if provided we indeed the support and specification, we can try to get these, our current things, make an amendment to match one of the examples that the USPTO has provided. So, when Alice came out, everyone was worried that, now software patents will no longer be patentable. And with some guidelines from the USPTO, we can give some guidance to clients as to how you can, which is ironic. One point is that in the Alice decision itself, the decision itself stated that, this is not an exercise for their attorney to overcome this rejection by, drafting more clever claims. But at the end of the day, with the guidance from the USPTO, it does come down to, if you focus your claims on more of the technological aspects of the invention, rather than merely, it used to be, if your claims were primarily, a computation or outputting an analysis. If you focus more on technological aspects, such as, as one example, you can, if you show data being transmitted to a device and a user interface gets updated in real time to reflect an analysis, that's an example that the USPTO has provided. I've actually used with examiners to get some rejections overcome, to overcome the one-on-one rejection. So I think in the future, I think we'll get more and more guidance from the USPTO on how to draft claims that at least the USPTO will be comfortable with allowing.
Mr. Hattori, what is the status of Japan? I know I've heard at least that computer programming is allowed. And to the extent, I think in the field of treatment methods and medical and biological, what is the status?
So in Japan, it's very not strict rule in the eligibility. We have only two requirements. One is industrial applicable invention, which is the same as utility, and also that is an invention. Only two requirements, and very open. The door is very open. So readable recording medium is patent subject matter. And unlike the United States, some extraction of the DNA, part of the DNA is okay, allowed, and but only one exception is a method of the treating or surgery of the human body is not a patent subject matter. We allow the animal other than human regarding the method of the surgery or therapeutic diagnostic method is okay. But on a human body, human method, the treatment is not. So, unlike the Indian law, fungi or microorganism is also okay, and atomic energy information is also allowed. It is because the Japanese Patent Office always open to the patentees or applicants to start the examination. So examiner need to show evidence about the novelty or events. So they always take the application and examine the case. That is our standard.
Rowan, how South Africa are different in that regard? And can you comment on Africa in general?
So the answer is clear, less clear for South Africa. We still have our Patents Act is the EU Patents Act, which has the standard exclusions of methods of treatment and software. We sit with two difficulties in interpreting that because we don't have examination, as most of you probably know, it's a registration system, and so examination effectively takes place through other jurisdictions. We would look at what had happened in, for example, Europe, and try and apply that in South Africa. And we don't have a lot of litigation, patent litigation, so a lot of questions are unanswered. So, for example, the software question is almost wholly unanswered. We don't have guidance, so we don't have much guidance from the court in some areas, or in a lot of areas. We don't have examination guidelines that one can fall back on to say, well, this is how it's going to be looked at. So what we've traditionally done is looked at the basis of our law, which is the UK law, and looked at what the UK courts specifically have done, where there's an absence of a UK decision. We would look at the EPO as almost the next best jurisdiction. Having said that, then we recently had a Supreme Court of Appeal case, which is quite recent, which almost holus just accepted English decisions into our law. So whereas previously you might have got the court saying, well, this is the way the UK has looked at it, and we think we could be different, or we could look at our own previous decisions. That decision almost seems to just say, well, if it's been decided in the UK on this basis, you can basically incorporate it. So with that, I would say, and our advice is always, look at what's happening in Europe or the UK. If you think you can get it through there, you probably will get it through in South Africa if it were to be scrutinized by the courts. As far as other African jurisdictions are concerned, the best I could say is that there's a strong, the EPO has exercised quite strong influence over many of the jurisdictions. So, for example, the REPO has the regional grouping that has got a lot of attention and assistance from the EPO, and you can. I think they focused quite a lot of effort on Africa as a whole and bringing Africa up. So my guess again is, the best guess is, in the absence of any real decisions, because you're not going to find many hard decisions in other African jurisdictions. In the absence of those decisions, you would again probably find a default to the EP European position, and take that as the touchstone what would probably be accepted as patent eligible or not.
We can dwell on this subject I have a volunteer. One of the issues in the software side is abstract. Now, one way of looking at it is, can a human being do it with pencil and paper, follow rules and technique, or follow that method with pencil and paper? Now, let's look at computer chess, way of playing chess. Computer chess is based on evaluating position advantages and exhaustively calculating all that and ranking it and picking the best. In an abstract sense, human beings can do it, but no human being does it. Human beings play chess in a different way. So can I make an argument that computer chess is a way of playing chess that was written exclusively for the computer? Even though in an abstract sense human beings can do it, no one does it that. Would that be a workable argument in support of patentability of computer chess?
You're asking me? What it should be or what it is? I think right now the answer is it would not be patentable subject matter. But I don't think that's correct. I think that's a mistake. I think that we need to really look at that. The scenario that I heard of when I was in the Patent and Trademark Office was similar, but it was something that would have taken 1,000 years to do if you did it by pen and paper, where a computer could do it in seconds, milliseconds, very short time periods. I think this whole subject matter eligibility issue is not where we should be focusing our attention. I think that's a big mistake in the United States, and it's going to cost us dearly in research efforts. I'm not saying that some of these claims should not issue. I do not like the claims that were in Alice. I thought the Bilski claims were terrible. I thought the Prometheus claims could have been better drafted. I thought some of the Myriad claims were a little bit problematic. I do not have a problem with people knocking out patent claims that are not clear, are not proper.